You're listening to Creative Confidential, a podcast for creative people about the law, art, culture, business, and the way forward. Presented by Tuk Business and Entertainment Law.
Greetings, everyone. Brian Tuk here with you. Welcome back to the podcast. Today we are talking about generative artificial intelligence, or let's just call that GenAI for the purposes of this episode, because I don't feel like spitting out all those syllables over and over and over again. So today, this episode is about GenAI and what not to do, what never to do with your smartphone or your laptop or your tablet. We're going to look at a case briefly that brings home why you should never ask your computer for legal advice, which seems like a silly thing to even have to say, but it has to be said because this is happening all over. People are trusting their technology, their smartphone, tablet, laptop, whatever. They're trusting their technology more than they're trusting people. And there's a lot of societal issues around these relationships that people are creating with their tech at the expense of interpersonal relationships with other human beings. It's bad for society. It's bad for the individual. I mean, there's a lot of, again, sociological stuff that we're just gonna push that to the side because that's not really why we're here. Here today, we're talking about legal issues and your computer. Let's get into this. Now, you may not know this, but for a long time, there have been many cases, and there are now many statutes, privacy-related statutes in the U.S. and elsewhere, about the privacy of your online communications. Now, what that might include, for example, is a search that you conducted on Google or Yahoo or some web-based search engine. Now, let's say you're involved in a litigation matter. Let's say you're the defendant, okay, and you've been involved in some situation and you're trying to figure out what your legal exposure is or what your alibi should be or what your defense should be. The last thing on earth you should ever do is go to Google and type in those types of questions. And here's why. Let's say for a moment that you're involved in a civil dispute, okay? We're in court, you're a defendant, and you have done something wrong, whatever that might be. You've breached a contract, and you go to Google and you type in a Google search that pertains to what you have done or what you haven't done, and you're trying to figure out what the legal ramifications of your actions or inactions, as the case may be, what the ramifications of those things are. Now, who you should be talking to is your attorney, okay, because you have attorney-client privilege in that communication. What is that? If you are talking to your attorney for the purposes of seeking legal advice, those communications are protected from discovery. No third party can find out what you talked about with your attorney. Now, let's change the fact pattern a little bit and bring it up to present day. Let's say let's change it to criminal because this is relevant to the case we're about to discuss. Let's say that you're a criminal defendant, and again, you haven't been convicted, you are presumed innocent, etc., so on and so forth. But you have received an indictment, you are aware that there is a criminal case that is about to become pending against you, and you go to Claude, or you go to Grok, or you go to ChatGPT, and you think that you're going to put yourself through ChatGPT law school, and you're going to start entering prompts in these GenAI products about how to structure your legal defense, what certain things you may have done, what effect that might have on the case, etc. Right? You get the idea. Well, that is in fact the fact pattern of the case that we're about to discuss. And what the case is in the New York federal court. So this is the U.S. District Court for the Southern District of New York, which sits in the city there. The case caption is United States of America v. Hepner. Again, everybody's presumed innocent. Whatever is involved in that case right now are only allegations. But all we're talking about is this particular discovery issue. And the issue in this case, here's the fact pattern. Let me set this up. The FBI arrested the defendant in this case and seized various documents pursuant to a search warrant. So far, so good. Among the documents that were seized were 31 documents that memorialized communications that the defendant had with Claude, which is Anthropic's GenAI platform. According to the court, these communications occurred after the defendant was served with a grand jury subpoena and was aware of a criminal investigation ongoing against him. This is from the court's opinion. So again, this is what the court is writing here. The court noted that, and I quote, without any suggestion from counsel that he do so, the defendant prepared reports that outlined defense strategy, that outlined what he might argue with respect to the facts and the law that were anticipated the government might be charging. Of course, the defendant moved to suppress the contents of those 31 documents, presumably on the basis that they are protected by attorney-client privilege, and also the attorney work product doctrine, which the attorney-client privilege protects communications between two people. The attorney work product doctrine protects documents, writings. So, in other words, if a client asks me for a legal position paper on any subject, it doesn't matter, and I send that client the position paper, that's attorney work product. That is confidential. It cannot be produced in a litigation matter to the opponent. So the court is now presented with this situation, and I believe this is one of the first reported opinions on this particular matter involving GenAI, that is. There's plenty of cases about search engine queries that defendants have used. That's well settled. This is an extension of that line of cases. But the court ruled that in the absence of an attorney-client relationship, the discussion of legal issues between two non-attorneys, the defendant and the GenAI platform, is not protected by attorney-client privilege. Repeat, is not protected. Now, it's interesting the way the judge worded that. Here's the quote: the discussion of legal issues between two non-attorneys. It almost confers personhood on GenAI here, if you will. That's a battle that is going to be on the horizon. We're going to see that. We are probably going to see that within the year in court. GenAI should have some legal rights or should be protected in the way that human beings are protected. I'm going to keep an eye out for that, but I'd be shocked if we don't start seeing those types of cases bubble up to the surface. I wanted to get this in front of you And I want you to be very careful with how you conduct yourselves with respect to what you're putting into these GenAI products. You do not have attorney-client privilege with any of these products. It does not exist. Everything that you type into Grok or Claude or ChatGPT, your opponent can get in discovery, can see exactly what you typed, can find out what you're worried about. That exposes the weakness in your case. You're handing it to your opponent on a silver platter. Don't do it. Enough of a lecture for today. I hope you all have a great time, great week, great month, whatever you're doing. And I will be back with another episode pretty soon. If you have any questions about this, you can contact me through the law firm website, tuklaw.com. Hit the online form and submit your question.
Thanks for listening. Be sure to subscribe to the podcast on your favorite podcast platform. You can also subscribe to the newsletter. Visit us on the web at briantuck.substack.com.